So I guess start with the assignment for today. Question number 1. Greg and Kayla. Greg and Kayla. So which of the following would be unenforceable because the subject matter is illegal? So what about, Greg, a contingent fee charged by an attorney to represent a client in a negligence action?
No.
No, because that's usually the way it's done. So that's very common. Kayla, what about a restrictive, an arbitration clause in a supply contract? That's fairly common too. Greg, what about a restrictive covenant in an employment contract prohibiting a former employee from using the employer's trade secret?
No.
That's common too. So Kayla, I hope the answer is D, because A, B, and C don't work. The employer's promise not to press embezzlement charges against the employee who agrees to make restitution. Kayla, the answer is D. So, and I think we discussed this last time. I think there are 2 reasons that it's that there's a problem with D. Greg, you can give me one. Kayla, give me the other. Greg?
The embezzlement charges, or the embezzling money against law already. So.
Okay. So the term press charges. The term press charges, Greg, implies a civil or criminal action. To press a charge is a civil or criminal matter.
Criminal?
Criminal, and in fact, if we wanted to say we were bringing a civil action, we wouldn't say press charges, we would say bring a civil action. So the first issue is, Craig, this is not something that is within our authority to do. That's something for the state to decide. But the other reason, Kayla, that the problem with D is
They would need to do more than restitution.
there's no consideration because you already have a duty to pay back the stolen money. Okay, so the answer is D. Question 2, AJ and Candace, AJ and, oh, there you are. Oh, no, there you are. Okay, sorry, and AJ. How come you got 2 questions? I like that. And also you got 2 names. And the one who does this for me doesn't know it. On May 28th, we showed an adult showing a minor use computer. So Candace, you be the adult, AJ, you be the minor. Candace, who is the power in the relationship? You the adult or her the minor? Legally, who is the power?
The minor.
She does, because she can hold you, but you can't hold her. So I think, Candace, we can limit it A, B, and C, because A, B, and C all say that the adult is liable. So therefore, AJ, the answer must be D. Candace, you agree? Now, question number 3, Allie and David. And notice the question is a tip-off because it's about the statute of frauds. But also notice the wording, or correct except. Do those 3 words, or correct except, they totally change the meaning? Because we're looking for the incorrect answer. Megan, if I misread the question and I saw which of the statute of frauds are correct, if I take out the word except, that changes the question. Megan, in a tax question, for example, in a gross income question, the question could be phrased, what is the exclusion? Or the question could be, what is the inclusion? Totally different concept. Notice the knowledge to answer the question is the same, but Candace, if you misread the question. So now what I'm looking for is, David, I'm looking for the wrong answer. So, what do you think? Any necessary writing must be assigned by all parties.
That is correct, so it's not the answer.
Contracts involving sell goods in amount greater than 500 must be in writing.
Also correct.
Contract terms must be contained in one document.
Not correct.
And contracts for which it's improbable to assume that performance will be completed within 1 year must be in writing. That is correct. So therefore the answer is C. So now, and I think as a matter of principle, probably it should be contained in one writing, but there's no requirement. Ali, you agree? Question number 4. Bichu and Tellini. Nolan agreed Orly would train to sell Trina House for $100,000. Now, Bichu, second. Normally, a contract for the sale of real estate has to be in writing to be enforceable, but there's an exception. What's the exception?
If the person take a partial of
Partial or full performance, and that makes sense because what the law says, if you change your position, then we'll exclude you from the requirement. So Tellini, that being the case, what's the answer to question number 4? B. You agree? Question number 5. Matthew, way up, Matthew. And Jody? Oh, you're in the same place. 5 people sit in the same place. So we have a contract, was signed off for sale, specified partial land on Fargo for $250. Crim and engineer had inherited the land, and I don't know what the relevance of that is, so maybe just cross that out. On the same day Crim's letter was received, Fargo telephone Graham and accepted the offer. Which of the following statements is correct under the common law statute of frauds? Matthew, how do you analyze this?
I mean, so once he like received the letter, then the contract was there, and then I guess like when you telephone him and accepted it.
So what's the answer?
D.
D. You agree? What's wrong with A, B, and C? No contract can be formed because Fargo's acceptance was oral. We still have a contract. The question is it enforceable? B, no contract can be formed because Crim's letter was signed only by Crim. Well, there's no requirement, Jody, that everybody sign the contract. Only the one who is going to be charged against. So, in a sense, Candace, this is similar to your transaction with AJ, where you were the adult and she's the minor. The power is in her hands. So, if you and I enter into a contract and I sign it and you don't, now the power is in your hands because you can enforce it against me. I can enforce it against you, so not all parties have to sign. And Jody, notice how often that comes up, that issue, a question involving whether all parties have to sign. Only the one it's going to be enforced against. Question number, Linda and Kobe, question number 7. Oh, sorry. Oh, I'm sorry. Question number 6, Katie and Taylor. So Katie, this is simple. If you've been adjudicated, and adjudicated is a legal term that means judged. If you've been declared incompetent, that means that you don't have the capacity to enter into contract. Therefore, Katie, the answer is C. All contracts are void. Taylor, as a matter of law. Notice, Candace, that's different from the minor. The minor can enter into the contract and hold the adult liable. But somebody who's been declared incompetent cannot even enter into a contract. It's almost as if, Katie, the person does not exist. Now number 7. Number 7, Linda and Kobe. Linda, what's the answer?
B.
B. Kobe, you agree?
Yes,
Why?
because even though consumer alcoholic beverages, it was not impaired.
So the key word here is was not impaired. Now, Kobe, in a real case, this would be a question of fact that we'd have to look to a jury to decide. So if you were the drunk, you're going to say you were impaired to get out of the contract, and Kelsey's going to say you were not. But notice we don't need to get into that because Kelsey says was not impaired. Therefore, you had 1 drink, you're fine. Question number 8. I guess the first question is, Kelsey, what's the contract for?
It's for Carson to repair rare books.
So are we buying the books or are we providing for a service? We're buying a service of the books. Service. Therefore, the statute of frauds says if you have a contract for the sale of a good, grading $500, that must be in writing, but that's not what this is. Therefore, does the statute of frauds apply? No, everybody agree. Now, Alex, oh, you hide. Now, Alex, so you agree, statute of fraud does not apply. And we had an original contract, and also it seems like, to me, Alex, the answer is either C or D. Can't be, I don't even know where 200 comes from. And it can be A because something was done. So we had a contract for 450. Before the work was started, Ives asked Carson to perform additional repairs. So now, and agreed to pay more money. So now, Alex, we have consideration going both ways. So you and I have a contract for me to provide a service to you for 450, and then we say, I'll do more work if you pay me more money. So therefore, Alex's answer is C or D. D. Had there not been consideration going both ways, the answer would have been C.
If it was a sale of goods, if it was just selling books, would it only be for the 450 then? Because the statute of frauds would apply.
So if it was to sell books, well, again, it's going to be a question of fact. If we view it as, good question, if we view it as one contract, then we don't have an enforceable contract for 650. However, if I want to enforce the contract, I'm going to argue what? I don't have one contract, I have two. One for 450 and one for 200. Does that make sense?
Yeah.
So if it is one contract, then the answer is 450, because 650 is beyond the statute of frauds. But I'm going to argue it's two contracts. That makes sense.
Yeah.
However, Kelsey, I don't think I'd see that on the CPA exam, because on the CPA exam we only see black letter law, not interesting cases. Good question. Question number 9. Sydney and AJ. AJ, well, you're special.
Yeah.
Sydney, where are you?
Right here.
You're not special.
No.
But you get to work with AJ. So Sydney, this contract should be in writing because it's more than a year. However, what's the however to this, Sydney?
He's fully performed.
Therefore, AJ, the answer is A. Does everybody agree? So, the notes for today. So AJ, even if we had all the elements of a contract, we have an offer, we have acceptance, we have consideration, we have legal subject matter, and we have legal capacity, and we met the statute of frauds requirement. AJ, sometimes the contract might not be enforceable because there's no genuine agreement. So for example, AJ, if I hold a gun to your head and I say sign the contract or else, we have an agreement. I made an offer, you accept it, but you accept it under duress. Therefore, we don't have a mutual meeting in the minds. Well, AJ, these are 4 ways to get out of a contract that you don't want. The first one that we'll discuss is mistake. Only mistake of fact, not a mistake of opinion, and Sydney, not a mistake of law, a mistake about fact. Unilateral mistake. Sydney, what's a unilateral mistake?
Only one party.
So you made the error and I didn't. Cannot be counseled unless, and here's an example, Sydney, sometimes in the law, the exception takes up more space than the rule. For example, on the covenant not to compete, Talini, the general rule is those are not enforceable. The exception is if it's reasonable in amount. So Michael, that actually takes up more space. And this is an example here. Unilateral mistakes cannot be counseled unless the other party to the contract knows or should have known that a mistake of fact was made, or if the mistake was due to inadvertent mathematical and without gross negligence. Then we can get out of the contract. And this, I think, is a handy example between a bilateral mistake. So if a unilateral mistake, Sydney is, well, one party makes a mistake. Unilateral is when both parties make a mistake. Bilateral mistake where both parties are mistaken, contract can be rescinded by either party. So Sydney, I offer to sell you my land for $100,000, not knowing that it's worth $500,000. You, not knowing that it's worth $500,000, accept. So now we have a bilateral mistake. So can I get out? Sure, because there's a fundamental disagreement about a material fact and it was on both sides. Unilateral mistake, well, only one party makes a mistake. And here, Candace, it's sort of a question of putting the burden with a minor. We put the burden on the adult. Here, Candace, we're going to put the burden on the one who knows about the mistake, not the one who makes the mistake. So, Greg wishes to sell his house to Tellini and wants to make her an offer of $200,000. However, due to clerical error, he actually makes an offer of $20,000. Greg, Greg, there you are. Did you make a mistake?
Looks like it.
I think so. Tellini, is it reasonable for you to know they made a mistake? And is this an easy mistake to make? But, Linda, let me make you the judge here. Clearly there was a mistake.
Yeah.
But thinking about this not in the context of what you know, but what might be disputed in a court, you know what the mistake was. Here's what happened, Greg. You dropped a 0. Well, Linda, how do I know he dropped a 0? He could have dropped a 2. See, you meant to say 200. But Linda, how do you, the outsider, the judge in the matter, or the jury, how do you know that it wasn't a 2 that he dropped, or a 5?
Because the 2 is still there.
I'm sorry.
The 2 is,
No. How do you know? How do you know that he didn't intend? How did you know that he didn't intend to say 220 and dropped? So the second digit is 2. In this case, the second digit is 1. So how do you know which one he dropped? You don't know. Does that make sense? Taylor, does that make sense? So we don't know. In this case, Taylor, we know what he dropped because I told you. But in a real case, you wouldn't know. Now, clearly, Tellini, he clearly did not mean to say 20, and we know they clearly did not mean to say 600. But, you know, 200, 220, 230, 240, all within the range of possibility. So, here's my question, Linda. What is Tellini's, and so Tellini, and I think Tellini, this is an example of bad dealing. Because you know, did you not know? Did you not know he made a mistake? And yet, you knew that. Everybody knows it. And yet, you took advantage of his offer. There's a place in hell for people like that. So here's my question. Linda, what's the remedy? Should it be to reform the contract? That is, to fix it, to put in what he meant to say, or is it simply to rescind the contract? Well, let me go back there. Let me play back the tape from like 3 minutes ago. Linda, do you know what he dropped? We know that he dropped perhaps the second digit, but do we know, Zenith, whether the second digit was 0 or 2? Could have been 3, could have been 4. Therefore, Zenith, it's impossible to know what he meant to say. So I asked you the question again. Now that we've reviewed that point again, let me ask you this question. What's the remedy? To fix the contract or to rescind it? Because you can't, and speak up, you're speaking to Angela. She said rescind the contract, and Tellini, that makes sense because it's impossible for an outsider to know what he intended. But it's also probably not fair to hold him to the contract because clearly, Megan, there was a mistake. Now, of course, Kelsey, if this were not unrelated parties, Kelsey, if this was a father and a daughter, it's possible, Michael, that there's not a mistake. But now I'm introducing facts, not in evidence. Misrepresentation, we're talking about mistake, now we're talking misrepresentation by conduct. Occurs when a party takes specific action to conceal fact that is material to the contract. Let's see. Statement of fact versus statement of opinion. Statement of opinions are not actionable. Can you help me with language? Actionable means what? I can't sue you for that. So if you tell me your opinion, if you say, this is the finest car that I've ever driven in my life. Michael, different people have different opinions. So I can't hold you to that. But if she says, Michael, that this car has 100,000 miles on it, when really it's got 400,000, I think you'll go to the same place in hell that she does. Then Michael, that's not a question of opinion, that's a question of fact, and we can't hold her liable for that. The exception, Michael, is that opinions from experts can be actionable, and the injured party can seek rescission of information. So Michael, give me an example of an expert. So if I say, if Kayla says, this is the best car I've ever driven, that's her opinion. But if Tellini, an art dealer, says that this painting is worth $100,000, that's not simply an opinion. That's an opinion of an expert, and we can hold her to that. Couple, you see the difference? Oh. Misrepresentation of law does not entitle a party to relief. And the logic here, Kobe, is you should know what the ignorance of the law is no excuse. Can this misrepresentation by silence or neither party has a duty to disclose facts. In fact, Candace is an old legal saying that says, let the buyer beware. So if I sell you my house, and my house has termite damage, you want to know that. I don't know why you hesitate. Of course you want to know that. But here's my question. Do I have a duty to tell you? You want to know it, but I don't have a duty to tell? So Michael, I don't have a duty to tell her the house is infested by termites. But she has a duty to ask. That makes sense? And if she asks, okay. So let's suppose, so let's go through the possibilities here. Let's suppose, Michael, that she does not ask, don't ask, don't tell. I'm okay, all right? Because who made the mistake? She did, because she did not investigate. She says doesn't have termite damage. I do not know, and I say not to my knowledge. Am I okay there? Because Taylor, I didn't really lie to her, did I? I said, to the best of my knowledge, I don't know. Now, Michael, when she hears that language, what should she do now? Get it inspected. I mean, first scenario was she doesn't ask, I do not tell. Second one, I do not tell because I honestly do not know. And frankly, I don't care because I'm dumping it on her. She asked and I lied to her. Is that different? But of course, Kelsey, the practical problem here is, how do you prove that I know? But then that's a question of fact. However, the seller will rely when she knows the material fact that cannot be reasonably discovered by a buyer. Now, Kelsey, that would not apply here, because she could simply get it inspected. And then, but wait now, Kelsey, I own the house. Won't she need, and you're the termite person to come in and inspect. Don't you need my permission to come and look at my house? Sure. But if I don't grant the permission to you to come check out my house, Candace, you probably should find somebody else to buy a house from. Okay. Misrepresentation. You must have reliance on misrepresentation. The deceived party must have justifiably relied on the representation. Cindy, you might remember in a legal environment I gave a test question. And the test question was that Joe Loser, that was his name, Joe Loser, was lied to by a group of investors and lost his shirt. And then on the witness stand, he said the following: the facts do not matter because I was so eager to invest with the bigwigs that I would have invested anyway. So let me state the story again. Joe Loser is deceived by Katie, and in fact flat out lied by Katie. But on the witness stand at the trial, he says, the facts did not matter. I would have invested anyway just to be in the same deal with Katie because I want to be in her company. Brendan, what did I just do to lose my case? I told the world, to include the 20 nuns on the jury, I told the world that there was no reliance. Does that make sense? So therefore, there must be more than misrepresentation. I must rely on that. So Michael, if what she says is so outrageous that no reasonable person would believe it, then there's no reasonable reliance. Reliance does not justify the innocent party, as me, knows the facts and relies on extravagant statements. Undue influence. Contract lacks voluntary consent and is voidable based on the confidential or fiduciary relationship or relationship of dependence. Examples is Katie, clergy. You could come in the influence of clergy. You could come in the influence of an attorney. You could come on the influence of an accountant. Kelsey, you care for your elderly 80-year-old grandmother, and she's totally dependent upon you. Could you, not that you would, but a person of less character could take advantage of that relationship. So undue influence, Kobe, is any time when you take advantage of your relationship to get a better deal. The last one we're talking about is duress. Parties who enter into a contract under fear or threat makes the contract voidable. So AJ, undue influence is when you use the relationship to take advantage of the person. Duress is when you use a threat. Threatening act must be wrongful or illegal and render the person incapable of exercising free will. So I say to you, Jody, I said to AJ earlier that if she did not sign this contract, I would, what did I say? Let's play the take back. What did I say? I would break your leg?
Yeah, that's in my head.
Oh, I'm sorry. I don't know what the damn threat was. Now, yes, suppose, Michael, that it was a toy gun, and she knew it. You know? Megan knows it's a toy gun. It's a water pistol. Megan, if she's a reasonable person, would she be in fear? No. But if it was a toy gun and it looked real, then it's reasonable for her to be in fear, and therefore you did not, AJ, of your free will enter into this contract. Threat of civil suit is not unlawful because, AJ, I've got a legal right to do that if I have a cause of action. I think we talked about this earlier with the consideration. AJ, what if I say to you, I will tell the police that you stole my computer, which you did not do. I would tell the police that you stole my computer unless you pay me $1,000. Is that which is a lie? So correct, I don't have the legal right to lie, do I? So therefore that would be improper. But now, yes, suppose that Brandon actually stole my computer. Now I have a legal right to enforce that. Economic duress is generally not sufficient to constitute duress unless the same party who created the need also requires the money. Does duress exist in the following situation? Peter tells David that he will break his arm if he does not sign the contract. David?
I'm not really afraid of Peter, but yes, that does count.
Notice, Brandon, that sometimes people sometimes people say, the question is it true or false? And they say both. Isn't that what he just said? I'm not really afraid of Peter, but yes. So, if you really, so if you're really not, so let's suppose that Peter is your roommate, and let's suppose that he's just joking. So then there's no real threat. But I think, AJ, that assumes facts not in evidence. I've introduced new facts.
Yeah.
If I just take what's here, is there duress?
Yeah.
So let's do it again. And this time, a simple yes or no would do it. Got it? Peter tells David he will break his arm if he does not sign the contract.
Yes.
Very good. But Brandon has a credit card with Biju's bank. His account is overdue. Brandon tells Biju that unless he's granted extension of time, he will file bankruptcy. Brandon, do you have a legal right to file bankruptcy?
Yeah.
Sure. Therefore, is that duress?
No.
No, you're doing something that, and I think Brandon, not only can you do this, but does the bankruptcy code encourage you to do this? Yes.
Yeah.
But now, ooh. What happened to my last question? Katie. The computer hates it. Oh, there it is. David and Katie are in the process of getting a divorce. David. Katie tells David that she will sue for custody of their children. Brandon, she got a legal right to do that? She have a legal right to sue for custody of the children?
Yep.
Sure. Unless she agrees to give her 90% of the couple's assets. Now, I think, let's look at this to leaning from a moral standpoint. What Brandon did in the other example is customary business. But this is disgusting. This is morally reprehensible. You agree? Megan, you agree? People that do things like this, Katie, burn in hell. The hottest portion of hell. Brandon, you agree? She's disgusting.
Yep.
And Katie, David, everybody that knows you advised you to stay away from this woman. Because she has, and I think taking advantage of the children. I mean, Linda, the objective is to do what's in the best interest of the children, and clearly that is not her concern. Clearly, she's a bad, bad, bad person. Did I say enough bads? But Brandon, is there duress? Does she have a legal right to do this?
Yes.
So is there duress?
No.
No. So I think, Cindy, this is a good example of something that is immoral, but not illegal. But you were still doing it now. And David, frankly, you're good to be rid of her. Last slide, we'll do next time. See you then. Cannot